On supplementary cost list, item number 1. May it please your lordships. Lordships, copies have duly been served upon the caveators of both the appeals. In 2 appeals I was supposed to serve, so I have served the copies. Now, my lord, I'll take your lordships.
Before my learned friend start, I'm challenging the maintainability of the writ appeal. Number 50, my lord. 50. Sorry. Okay. Yes. My lord, may kindly see the.
Are you a party here?
Yes, I am a party, my lord. I am for respondent number 1, my lord, in this matter.
Why maintainability?
My lord, here, my lord, what happened? If my lord see the rule, Meghalaya High Court rules, my lord, chapter 3, my lord. Yes. Page 8, my lord, of Meghalaya High Court rules, my lord.
Yes.
Para 4, my lord. Serial number 3, my lord. The appeal shall be in the form prescribed. In the case of a writ appeal, the certified copy of the judgment, authenticated copies of the civil writ petition with relevant annexures, copy of the affidavit, counter affidavit, and all other relevant papers filed by the parties concerned in the relevant civil rule writ petition for which the appeal has been arisen must be filed along with the memorandum of appeal, my lord. Now, my lord, the documents which was filed, my lord, has not been enclosed here, my lord. This is the documents, my lord, all the documents which has been filed by various parties, my lord.
No, what is required is, let's go here.
Yes, my lord.
Copy of the writ petition.
Yes,
Have
my
you done
lord.
that?
Yes, my lord.
The certified copy of the judgment, authenticated copy of the writ petition.
Copy of affidavit in opposition.
Yes.
Yes,
Yes, my lord.
So,
Copy of the affidavit in opposition. All the affidavit in oppositions are not part of the appeal of memo, my lord.
okay. You have not annexed.
My lord, the records which was there with me, that was the complete record. Because prior to me,
The case cannot be filed on the basis of the record of my friend.
I may be allowed to complete. The records were initially, this particular case was initially handled by Mr. Shangrezo on behalf of the appellant. And when the records were provided to me, the affidavit in opposition of the respondent number 2 was there, the respondent number 4, myself, it was there. And that is what I have annexed, my lord. And so far as rejoinder is concerned, I checked today morning also the list, the order sheets, whether any rejoinder has been filed. But rejoinder has not been filed. There was a previous order of 11th March 2021 in the writ petition, which stated that Mr. S. they had prayed for time to seek final instructions from his client, because he was the writ petitioner in this particular case.
Whatever the case may be,
My lord.
only those papers which are, part of the, the writ proceedings.
My lord, whatever was served upon us, that has been annexed. Whatever was served upon us. Because I was a private respondent in the writ petition.
Okay.
So, the respondent number 2 filed the affidavit, and it is the same affidavit, my lord, if your lordships recollect. I was referring to one particular affidavit where the state government has stated that Nazila Begum is occupying a non-sanctioned post. So, it was that same affidavit filed by the SSA respondent number 2. So far as respondent number 4 is concerned, I was the respondent number 4 in the writ petition, and I have enclosed that as well.
Okay, whatever is in your possession.
Yes, my lord. Whatever is there in my possession, I have enclosed.
My lord, the respondent, I was the writ petitioner in this matter, my lord. The respondent number 3 has filed their affidavit. Is she, my lord, her client. That itself is not enclosed, my lord, in the writ appeal.
I was respondent number 4 in the writ petition. I was not respondent number 3.
She has filed as both as 3 and 4. She has filed as the secretary of the school managing committee, and she has also filed because we have made him as a person in his personal capacity.
Page 94.
My lord, that can be corrected, my lord.
My lord,
That
it
can
is
be corrected. Then
affidavit-
only the clear picture will come.
Of course, the High Court rule says must be added.
Yes.
My lord, I have not filed as respondent number 3 and 4 both. It is at page 94, the affidavit in opposition filed by respondent number 4, because this particular Khetadova UP school managing committee, which was the respondent number 3 in the writ petition, my lord, as far as my instructions are concerned, he was not the secretary. He became the secretary or the convener of the managing committee from 2018. Not prior to that, my lord. It was from 2018. It is in personal capacity. It is not in on behalf of respondent number 3 as well.
Probably my friend has not been instructed properly by her client, my lord. These are the affidavits.
And I fairly submit that today morning I checked the document details which my learned senior is referring to. In the document details on the e-court services, it shows that there are separate affidavits for respondent 2, 3 and 4.
What is the problem in verifying the record physically? And see, whatever is filed in the writ petition, that has to be enclosed here. That is what the High Court rule says.
Indeed, my lord, it is absolutely true. I don't deny that.
Why to make a small thing big thing?
I'm not at all denying that.
Incorporate those things which are missing.
Lord, we will incorporate, but my lord, my only humble prayer is, Lord, next week there are only 2 working days. We have been on this particular case. Today is the 3rd day I'm appearing before this on.
See, if you commit yourself to check all these things, we'll take up the matter tomorrow.
My lord, tomorrow
Otherwise,
again, my lord.
What is tomorrow? Tomorrow is Friday.
My lord, I have not come for a stay. Coming again and correcting within 1 day. It is not possible because it will require the signature of the appellant who is from Garo Hills. Applying for a copy of the records from the registry, getting it, and then filing an affidavit, and then the matter being taken up tomorrow.
But then if it is a requirement, will you?
My lord, in this particular, my lord,
not
my
complying
lord.
with the.
Okay, my lord. The objection is in writ appeal number 50. Writ appeal 50. So writ appeal 50, I pray for some time. Nothing may be done with regard to writ appeal 50, and I will start my argument with item number 2.
Do it. Why not?
Yes, my lord.
Common order, it is common judgment.
Doesn't matter. But then
But
deficiency
the writ
is
petitions
50,
are different and the
so it
issues
is
are
not
different.
51. What is the problem?
It's a common
If
judgment.
51 is complete, we will go by 50.
51 is complete, 52 is also complete, my lord.
We're here on technicalities now.
Now, if my lord is insisting on taking up writ appeal number
We are not
50.
insisting. Why should we insist?
No, I'm just saying, my lord. I'm corrected, my lord. If my lord is taking up item number 51, my lord, writ appeal number 51, then even I have an objection that same documents are not there. Moreover, my lord, the
Which
honorable
documents are not there in that particular case.
Please let me address the court. My lord, here what happened, my lord? The honorable learned single judge, my lord, has decided a matter on the basis of an inquiry report, my lord. That inquiry report is not before this honorable court, my lord.
My lord, inquiry
inquiry
report
report
has
was not
never
even-
been provided to us.
No, that is not correct, my lord.
It is
Inquir-
absolutely correct. Absolutely, I can prove it, my lord.
You submit, then I will submit.
I can prove it. Yesterday also the same query fell from your lordships, that was it recorded in the order that you have prayed for the inquiry report, or was it recorded in the order whether it has been
That is on the
denied?
basis of your submission.
My lord, that is why the proof is
You
there in the
say
live streaming.
That no copy of the report was supplied to you.
Yes, my lord.
Okay. Now, of course, we have not checked the record of
It is
the
only a
submission.
verbal submission which we had made, and it was a verbal prayer made before the court.
That is what the problem is. You see, how do you prove it?
My lord, the live streamings are there. That is why
We are
transparency
going
has
to go
come.
to that extent. Not possible.
You think? Yeah.
And my lord, one more thing. Even if even if the inquiry report would be on record, we did not receive, so we cannot. But the point is, the Commissioner and Secretary to the Education Department was directed to conduct an inquiry. After perusal, my lord, the Secretary to the Education Department was a party to the
Anyway,
proceeding.
we'll take up 50, 51 and see. As far as 50
Yes,
is
my lord.
concerned. Oh, there's a caveat, isn't it?
No, 51 we
It
don't
has,
have caveat.
in 51 there is a
51 we don't
caveat
have
copy.
caveat, but
50?
51 is there, my lord.
51 there is a caveat,
Caveat,
and I have already served the copy.
So,
That has to be
caveat will be
discharged.
discharged.
My lord.
Yes, my lord.
Then again, my similar submission will be,
let's look at 51.
Shopin, give me the.
Now, what is your objection here?
My objection will be this, my lord. A common order was passed, and on the basis of an inquiry report, my lord. Now, my learned friend has filed an appeal, and definitely she has procured the judgment of the court for filing an appeal, my lord. We apply this judgment, my lord, and we also apply an uncertified copy of the report after the judgment was delivered, my lord. This is the report. We have the report, my lord. Why she could not get the report?
My lord, getting an uncertified copy after the judgment is passed and hearing of the matter by after supplying a copy of the inquiry report, there is a drastic difference between the two. Because when the inquiry was conducted, I was heard. I admit that. I was heard by the inquiry officer and I had produced some documents. But the judgment, when the entire judgment is based on the inquiry report and I have not been heard on the inquiry report, my lord, the entire matter goes there itself. Because the documents which I placed before the inquiry officer, I do not know whether it's a part of the inquiry report or not.
My lord has to produce to
See,
answer
first-
this, my lord.
First, we have to ascertain as to whether you have received the inquiry report.
My lord, before
You say no.
No, my lord.
But according to Mr. Day, the inquiry report is on.
My lord, he is also saying that he.
It is
My
in the
lord,
record.
it is on in the court record. It was submitted by the government advocate to the court. The court perused the inquiry report and passed the entire judgment on the basis of the inquiry report. Now, my lord, if I may say one small submission, I hope I don't offend this honorable court or my learned senior as well. My lord, if the inquiry report would have been provided to all the parties concerned before reserving the matter for judgment, why would my learned senior or his client apply for an uncertified copy of the report after delivering of the judgment? That makes no sense at all. This proves that
Now,
the inquiry
to
report
answer this,
was
my
not
lord,
provided
to
to
answer
us.
this-
This clearly proves that the inquiry report was not in the possession of the parties prior to passing of the judgment. Otherwise, the need for applying for an uncertified copy would not arise.
That's logical, of course.
It is absolutely logical,
We are
my
not
lord,
saying-
as your lordship
we are not
is saying.
submitting before this honorable court that the copy of the report was furnished to us prior to delivering of the judgment, my lord. What was my submission before this honorable court was this, my lord, that if she intended to get a report, my lord, after the judgment also she could have procured the copy of the inquiry report. Now, my lord, just a minute, my lord.
One thing is certain.
Yes,
that
my
the
lord.
inquiry report was not furnished to any of the parties.
Yes, my lord. Why and why it was not
The
furnished?
single judge relied on the inquiry.
Yes, my lord. I can
Yes,
read out
yes.
the entire judgment before your lordship.
Now, for what reason the inquiry report was not furnished, my lord? This order has to go through. My lord has to go through this order, my lord, of the learned single judge. Why an inquiry report was called for?
Let us
Page
not place a
89.
case. Let us-
My lord.
You will reply.
Page
come this
number
side then,
89.
You come this side. You are sitting. Sir, we'll argue. You come this side. No, it's okay.
You be there. Let me.
I think you feel good that you are sitting this side.
Now, if I may take your lordships to page number 89 of the memo of appeal.
Yes.
Your lordships will kindly permit me to read the entire judgment. I will take not much time of this honorable court. These matters where the common issue involves the service of the teachers of Khetadoha SSA UP school are being taken up and disposed of by this common order and judgment. Now, my lord, with regard to this particular point, my lord, my humble submission is there were a batch of 7 writ petitions. Out of the 7 writ petitions, the first writ petition being WPC 383 of 2017, against which I have preferred an appeal, which cannot be taken up now because some documents are not there, writ appeal 50. My lord, in that particular case, the prayer of the petitioner was only to disburse her salary for a particular period of time of 2017. This particular case, writ appeal 51, if I may take your lordships to the prayer portion, my lord, of the writ petition. Page number, my lord, 20. And I will come back to the judgment after submitting on this.
You want to say these matters were clubbed together without your consent?
My lord, the direction...
Without your consent.
My lord, common judgment came without consent. The consent...
Together, when these were heard together, did you register any consent?
My lord, the matters were not tagged. It was simply stated that since all these cases relate to one school, let all the cases be listed on a single date.
Then we have to scrutiny the entire order sheet of the single bench.
My lord, I don't say that listing all the cases on the same day.
You yourself said yesterday these matters were heard in February.
Sorry, my lord?
Matters were heard in February 2023. It was reserved for judgment.
Yes, my lord.
Then in the month of June, July, it was released.
Approximately.
Subsequently. It's okay. We are going with it approximately.
My lord.
Dates may not be that relevant.
Yes, my lord.
And then subsequently inquiry was
It came
ordered.
up for orders and then inquiry was
all
directed.
along those matters were listed together.
Yes,
together.
My lord. Yes, my lord. In fact,
kind
since...
of objection you are raising here,
No, my lord, I am not raising objection on the taking up of the matters on a single date. Because since the issues related to the same school and the fate of the children needed to be taken care of...
matters were not supposed to be disposed of by common judgment.
Yes, my lord.
That has been done without consent of the party.
If at all a common judgment is being passed, every single issue should have been delved into separately. The issue has been clubbed here as it relates to service of the teachers.
That is why it's been clubbed here.
My lord, in all the cases, the prayer was not with regard to service. Most of the cases, it was disbursement of salary, constitution of managing committee. In this particular case, of course, it is with regard to the service because the appellant herein had challenged the appointment of respondent number 4 as an assistant teacher on the ground that the managing committee, which comprised of 11 members, out of the 11 members, 6 members were her own family members, and that is there in the pleadings.
So that means your first challenge is that
First,
there could not have been a common judgment. That is your first challenge.
My lord, I am not saying that the challenge is on common judgment. My only submission is, even if it is a common judgment, the issues could have been dealt with in separately. Like, if your lordship, if I'm being able to convey what I mean.
No, that is understood.
It may be a common judgment, but the issues should have been dealt with. Now, my lord, in this particular case, the pleadings, if I may read just one paragraph of the writ petition, my lord, that the said illegal appointment was made as the stage was set to do so while obtaining the order of the constitution of the managing committee, which comprised of the following relatives of the respondent number 4. Number A, Sobhan Ali, he was the secretary of the managing committee and he was the father-in-law of the respondent number 4, whose appointment I have challenged. Second person, Hussain Ali Sarkar, he was a member of the managing committee. He was father of Sobhan Ali, who is again a relative of the respondent number 4. Number C, Abdul Ghaffur Khan, member, son of Sobhan Ali. Syed Hussain, member, brother of Sobhan Ali. Srimati Reliza Begum, member, sister-in-law of Sobhan Ali. Gyashuddin Ahmed, member, husband of the respondent number 4. Out of 11 members in the managing committee, 6 members were the family members of the respondent number 4 whose appointment I have challenged. Second ground of challenge in the writ petition was that no advertisement was issued to fill up the post. No advertisement at all. This Gyashuddin Ahmed, the husband of the respondent number 4, had resigned, and upon his resignation, this particular resolution was passed by the managing committee, where the 6 members were the relatives of the respondent number 4, without issuing any advertisement. So far as advertisement is concerned, I would concede that the learned single judge has given a direction that all future appointments are to be made after advertising the post. But so far as the illegality of the manner in which the respondent number 4 was appointed as an assistant teacher, there is nothing. Now, my lord, if I may continue with the judgment. Page number 89.
You were referring to the order, the prayer?
Prayer, my lord, I have covered with that particular para itself. I was just challenging the appointment of the respondent number 4. In this case, it is true that the service of the respondent number 4 was challenged. Now, if I may take your lordship to para 2 of the judgment. The genesis of the controversy which has engulfed the school, which has seen multiple and protracted litigation repeatedly before this court, with claims and counterclaims which had become difficult to adjudicate, occasioned for an order of this court dated 7/2/2023 to be passed, directing for a full-fledged inquiry to be instituted by the Commissioner and Secretary Education Department. Pursuant to the said order and after grant of extension of time for completion of the inquiry, the report was submitted on 21st July 2023. Now, my lord, the Commissioner and Secretary was directed to conduct the inquiry. If your lordship kindly sees the memo of appeal cause title, the respondent number 1. The respondent number 1 is the state represented by the Secretary of the Education Department. My lord, the person who is a party to the list has been directed to conduct an inquiry, and his own subordinates are filing affidavit in the matter. The state government itself is a party to the list, and the secretary himself is a party to the list. So after getting instructions from the subordinates and directing the subordinates to file the affidavit, can an inquiry be conducted by a party to the list? It is equivalent to, my lord, the judge deciding his own case.
Then who would do the inquiry?
My lord, we had prayed for a CBI inquiry. That is again
That is
verbal.
your prayer.
Yes, my lord. That was
It is
again
illegal.
verbal.
Why it is illegal? Just because somebody is a party cannot conduct inquiry, where is the problem?
My lord, this is just, my lord, the judge is judging his own case, because this entire judgment,
Party is not judge in a matter.
this entire judgment is on the basis of inquiry report.
Why? See, acceptance is reported is something different.
My lord, if I may,
Then you cannot say that inquiry cannot
my lord,
be
if I cannot satisfy your lordships on this point,
no,
we
you
may
have to
proceed
bring
further.
us something. Give us something. Show
My
something
lord,
on
that was my humble submission. If your lordship is not convinced, it may be.
Have some basis, isn't it?
My lord, that is the basis, that he himself, he is a party to the list, and he is preparing the entire inquiry report.
What is the
The
problem in
entire
it?
inquiry report.
What is the problem in it?
My lord, his
If a
affidavit,
officer becomes a party to a list, he cannot investigate the matter.
my lord, his affidavit says something else. His inquiry report says something else, which I have already pointed out
That
yesterday.
may be a ground. That is good ground.
My lord.
But then to say that cannot conduct inquiry, that is
Now, my lord, proceeding further, my lord, before adverting to the report, which is detailed and conclusive, it is relevant to note herein that, due to the disputes that have arisen, coupled with unauthorized and illegal actions of some of the players herein, both from the official side as well as the teachers, the salaries of the rightful recipients amongst the teachers have been withheld. A case in point is WPC number 383 of 2017, wherein the petitioner, who is a sanctioned teacher, namely Srimati Nazila Begum, has not been paid her salary from the month of January 2021 till date. My lord, the writ petition is of 2017. Her prayer relates to 2017. But the finding by the learned single judge is that she has not been paid her salary from January 2021. Whereas, my lord, I am not being able to refer to that particular appeal right now because the records are incomplete. Whereas in that particular case, I have filed my affidavit in opposition, which clearly shows that she had already been terminated from service prior to filing of this particular writ petition number 383 of 2017. And that particular termination order was suppressed by the petitioner, and she approached this honorable court claiming her salary.
These are all factual disputes. To what
My
extent
lord,
this court go and
My lord,
find
this
out
is
those?
this is the admission of the petitioner that she was not receiving salary.
If you say in view of what you say,
My lord, not in
say
view of what my
what version you bring, there is a possibility of taking a different view. Just because that is possible, can you interfere with the finding of the
my lord,
High Court?
I may be permitted to substantiate it
Until
further.
unless you show that this finding is not based on
If
any
I may
material.
be permitted to substantiate it further, my lord. The writ petition was filed in 2017. How can she make a prayer for salary with effect from January
That is not on
2021
basis of her prayer. The court has made its own finding.
on the basis of the
Because
enquiry
this matter
report?
remained pending, decided after 2021.
My lord, she had already been terminated from service.
That is what you say.
My
That is
lord,
what you say.
the document is there. That has not been referred to in the entire judgment.
That is a factual dispute.
My lord, that has not been referred to in the entire judgment. In the
No,
entire
that is-
judgment.
See, if you say about that, then the question will come: who are you? What is about your
My lord,
qualification?
I am the head teacher.
What is-
I
what
have
is your- what is your
yes,
qualification?
yes, my lord. I can show it from here, from
There
this
is a
record
finding
itself.
that you also were terminated from job in 2020.
No, my lord. There is one
You
more.
say no.
There is one more aspect to this matter, my lord. There was prior to this particular inquiry being conducted on the strength of the order passed by the learned single judge, an inquiry had already been conducted. The report was submitted. It was dated 4/8/2021, and I had filed a rejoinder in this particular proceeding itself. The report dated 4/8/2021, my lord. It is at page number 83, my lord.
Yes.
Page 83 report.
Your rejoinder is after the inquiry,
No, my lord.
before the inquiry.
Prior to the inquiry. The rejoinder report, my lord, this is an inquiry report at page 83, which was annexure 13 to the rejoinder prior to the inquiry.
Inquiry dated?
Inquiry dated 4/8/2021, conducted by the district mission coordinator.
All this inquiry has been set aside by this honorable court, my lord.
Your time will come. Don't get impatient.
No, my lord, because I want to just refer the order. Managed inquiry, my lord.
I will be reading the entire judgment. If I may read this report, my lord. The report has been prepared in view of the dispute in Khetadoha SSA UP school,
This is a report dated
4/8/2021. The date is mentioned at page 86. It is mentioned at page 86.
This is the report on the basis of the order of this court.
No, my lord. No, my lord. That inquiry report, we are not yet privy to it, and we did not apply for a copy of the same as well.
And how was this, report,
This report, my lord, is a part of the rejoinder which I had filed in the writ petition. The report has been prepared in view of the dispute in Khetadoha SSA UP school. In this school, a pending issue since 2016 regarding sanctioned and non-sanctioned posts between Shri Nurul Amin and Srimati Nazila Begum, and further a dispute regarding head teacher of Khetadoha SSA UP school between Shri Nurul Amin and Srimati Shobuza Begum. In this regard, a report was prepared on dated 6th February 2020 and passed an order dated 2nd March 2020 by the then District Mission Coordinator SSA Tura, replacing Shri Nurul Amin as non-sanctioned teacher. However, the report dated 6/2/2020 was made without taking documents from Shri Nurul Amin, headmaster cum convener / ex officio member of the existing school managing committee, as well as without examining the several orders which were issued in favor of Shri Nurul Amin, BA DL8 by the then Joint District Mission Coordinator Dadingiri. This office received a representation dated 29th April 2021 from Shri Nurul Amin and decided to re-examine the report dated 6 February 2020 and order dated 2nd March 2020, and hence the said order has been kept in abeyance until further order, by order number so and so dated 13th May 2021. On scheduled date of the meeting, that is 4/8/2021, the District Mission Coordinator SSA Tura, West Garo Hills, chaired the meeting assisted by Shri D.K. Nevar, Administrative and Account Officer SSA West Garo Hills Tura, and the following persons attended in the meeting. Number 1, Shri D.K. Nevar, Administrative and Account Officer SSA West Garo Hills Tura, Shri Amit Ghimiri, District Program SSA West Garo Hills Tura, Shri Mofial Haq, Cluster Resource Coordinator Belbari West Garo Hills, Shri Abdul Wahab, Chairperson, and Shri Nurul Amin, Convener of the existing School Managing Committee of Ketadhova SSA UP School. After briefing the purpose of the meeting, the following observations were recorded as under. Number A. The school was upgraded from Ketadhova Government LP School under SSA in the year 2010. At the time of upgradation of Ketadhova SSA UP School, the then District Mission Coordinator SSA Tura issued circular to constitute School Managing Committee with following terms and conditions of SSA, and the same committee was empowered to select only 3 numbers qualified teachers with a minimum qualification 10+2 or PU pass, and the resolution should be duly approved by the concerned authority as per terms and condition of SSA laid down by the government. It was also mandatory for the selected teachers to undergo 15 days induction teachers training program against the 3 numbers of sanctioned posts of each school. A letter was issued to Shri Mofial Haq, Cluster Resource Center Coordinator Belbari, on dated 4/6/2021 and instructed to submit a report of teachers of Ketadhova SSA UP School who has participated in the induction teachers training program in the year 2010 with the position of sanctioned posts. Accordingly, the CRC Belbari...
What is the purpose of going through all this?
My lord?
What is the purpose of going through all the details?
The purpose is, my lord,
Just
the
give
finding...
the gist of what you
the
want to
gist
say.
is, this particular report, clear the main finding, my lord. I'll just come directly to the main finding. At page 85, last paragraph. Serial number 1 under paragraph 11. Has decided to cancel on the following grounds. The order dated 2nd March was cancelled on the following grounds. Number 1, that Ketadhova SSA UP School was started with 3 number sanctioned teachers with a minimum qualification 10+2 or PU pass as per order of the state government, and the name of Shri Nurul Amin is in the founder teacher list. He was a founder teacher, my lord. That the existing school managing committee has submitted a report.
Visible here. You see, you have not.
My lord, this copy which we have received, the first few lines.
You must get it typed. You see, you do not give that kind of excuse just because you received. You should make this, compel the court also to read it.
My lord, it was checked by the registry, and the pages which were directed us to be typed, we have typed and incorporated.
Checking by registry will make this line visible. Just tell us.
My lord,
I do not know what kind of things you see.
Lord, if I may continue.
Not expected of a counsel.
I apologize, my lord. I'll take care, my lord.
Make sure that whatever copy you give to the court must be able to read it. Otherwise, what is the use of annexing this? Is there any use?
My lord, if I may proceed further. That the existing school managing committee has submitted a report dated 23/7/2021 in respect of founder teachers of Ketadhova SSA UP School and the name of Shri Nurul Amin attended in the induction teachers training program as per SSA norms. That the Cluster Resource Center, Belbari, report dated 12/6/2021 that Shri Nurul Amin is a founder sanctioned teacher as per records. That the Joint District Mission Coordinator, Dadingiri, West Garo Hills, Meghalaya, has submitted a verification report of office order or letters on dated 12/7/2021 and found all the letters or orders are correct, which clearly prove that Shri Nurul Amin approved as language teacher, senior most headmaster, and lastly finalized as headmaster of Ketadhova SSA UP School. That the approval order of Srimati Nazila Begum as sanctioned teacher was cancelled by the higher authority on dated 7/3/2017. That Shri Nurul Amin completed BA DLEd taking prior permission from the higher authority. Thus, in conclusion, it may be stated that the appointing authority appointed Shri Nurul Amin in the sanctioned post from the beginning of the school, and same was approved as language teacher and thereafter finalized as headmaster of the school. Therefore, in this meeting, it is considered that Shri Nurul Amin is accepted as language/headmaster of Khetadoa SSA UP school, and Shri Abdul Rafiq found as a founder teacher. So he is considered as social studies teacher. And lastly, Srimati Shobuza Begum is allowed to continue as science teacher of the Khetadoa SSA UP school till the final judgment of the Honorable High Court of Meghalaya in WPC number 264 of 2020. 264 is where the appointment was challenged, the present writ petition. Srimati Sabina Yasmin and Srimati Nazila Begum placed in the additional teachers list. In view of the above, and in the interest of all concerned, and for the well-being of the student community and the smooth functioning of the school, the report wide number so-and-so dated Tura the 6th of February 2020 and order number so-and-so dated 2nd March 2020 are hereby cancelled by the undersigned. Now, my lord, the founder teacher, it has been in this report that Nurul, the appellant, was a founder teacher of the school. My lord, this after this particular report was submitted by the DMC, a number of writ petitions have been filed by Srimati Shobuza Begum, which can be proved here itself. In 2021 itself, Srimati Shobuza Begum has filed 2 writ petitions. But my lord, this particular report has not been challenged in any of the writ proceedings. Not a single writ proceeding. So, this report stood as it is before the enquiry was directed by the learned single judge. Now, my lord, if I may go back to the judgment.
I would like to submit, my lord. Whatever my learned friend is submitting is misleading, my lord. It's very, very unfortunate to point out.
I'm just
let me
reading the
submit, my lord.
reports.
These orders, which my learned friend is insisting on, my lord, this order has been set aside by the learned single judge prior to the judgment. That has not been brought into record, my lord. My lord.
No, my lord. 4/8/2021, my lord.
7/2/2023, my lord. My lord may kindly peruse the orders. All these orders, my lord, which my learned friend is reading, my lord, it's all set aside, my lord. It's unfortunate.
7/2/2020.
My lord, I have 3 copies. Yes, we can share, my lord.
Sure.
Yes, please. You can read from para 2. You please read from para 2.
In this school, as it appears from the records and also from the materials as placed by the parties, 5 teachers are in contention for the 3 sanctioned posts with their respective claims. In the course of time and in the course of multiple writ petitions that have been filed, enquiries had also been conducted to ascertain as to the correct position as regards the status of the teachers in the said school. In fact, 4 said enquiries were gone into on 3/10/2017, 6/2/2020, 2/3/2020 and 4/8/2021. It is noted by the last report dated 4/8/2021.
You can share.
The DMC
So this is the report. You
had rendered findings on the status of the teachers apart from cancelling the earlier reports. However, this report was also put to challenge and another enquiry on the report dated 4/8/2021 was conducted by the administrative officer SSA. Lord, a copy of this, I don't know, we don't have a copy of this particular report. This is court order.
This is not under
You
challenge.
cannot say that you do not know.
I have not challenged this order, my
This is
lord.
not under challenge.
Yes,
Now,
that's
how
what
can
I'm
she can
submitting, my lord.
overlap, my lord?
That is what I'm submitting, my
Your
lord.
lordship, lordship, I have a submission, your lordship.
My lord,
I have a small submission. Whether your lordship, the writ appellant here, your lordship, the finding of the learned single judge, as well as the finding of the inquiry that he had manufactured one document. Whether your lordship will hear the polluter of a justice.
My lord, I'll come to that. I will address that issue.
Lordship, what happened? Lordship,
we are not going to the merits of the impugned order as yet.
Yes, my lord. This is this
because
admission
the finding
stage.
is very clear that he had annexed in the writ petition, in one of the writ petition, your lordship,
A duplicate.
a forged document, your lordship.
My lord,
Whether
it's
your
a
lordship-
state
whether
government
your lordship
document.
will hear a person who has polluted the temple of justice.
My lord, it's a state government document which has duly been signed
That
and it is
document
a part
was
of...
manufactured, my lord.
My lord, I may be permitted to complete. The respondents will definitely get their chance.
Please.
I was at paragraph 3 of the judgment, my lord, and thereafter I had gone to the report dated 4/8/2021. So this 4/8/2021, my lord, yes, that is not under challenge. This particular order which says so, that a subsequent inquiry was conducted. The findings arrived at, apart from observing that the said report dated 4/8/21 was invalid, controversial and misleading, the action of the said officer who conducted the said inquiry was also found to be unbecoming to the post she held, and in fact an explanation was also called for from the said officer. So, my lord, this was between the government and
You should
them.
have read out this thing.
My lord,
Once you have failed to challenge
this
it,
is a different order, my lord. I
you
skipped
should not
this.
have referred this 4/8/21. After you should not have.
My lord, I
It
am,
is improper on your part.
my lord, I am on the judgment now. On the judgment, the impugned
Make sure
judgment.
that
Yes, my
She
lord.
cannot say, my lord, I am aware of this, I am not aware of this. She cannot say that, my
Once
lord.
your image goes down, then what would remain? Just
Indeed, my lord. I completely, I am deeply obliged that your lordship has pointed this out, because your lordship is in a position to guide me.
Therefore, you see, you should not confuse the court with.
Indeed, my lord. So I'm again,
Come to the point.
Astray, your lordship.
I'm going to
The
the,
writ appellant is going astray, your lordship.
again, my lord,
Just
I
a moment,
apologize.
just a moment.
Now, para 4, my lord. Page number 90. Para 4. The inquiry report which has been furnished has, however, clarified the issues in contention and has shed light as to the nature of the controversy involved in the said school. In this context, therefore, this court finds it expedient and necessary to rely upon the same in the adjudication of these cases. My lord, not a single pleading has been taken note of in the judgment. The inquiry report has not been provided to us prior to pronouncement of the judgment, because we were not privy to what was there in the inquiry report at the time the judgment was passed. And the entire judgment is solely on the basis of this. Proceeding further, my lord. As per the report, the history of disputes between the... Yes, my lord.
yes, please.
Proceeding further, my lord. As per the report, para 5. As per the report, the history of disputes between the teachers and the managing committee of Khetadoa SSA UP School involves 3 significant phases. First phase, February 2010 to January 2017. Second phase, February 2017 to 27 September 2019. Third phase, 28 September 2019 to 5th February 2021. In the first phase, the school was brought under SSA in February 2020, and it was instructed by the DMC that the school managing committee should be constituted and 3 teachers, that is 1 language teacher, 1 science and mathematics teacher, and 1 Hindi teacher with diploma was to be appointed. The same was done by the resolution dated 3/3/2010, and 4 teachers were appointed, namely 1 Gyasuddin Ahmed as head teacher, Abdul Ghaffur Khan and Abdul Rafiq as assistant teachers, and 1 Nurul Amin as Hindi teacher. My lord, the direction was also to appoint 1 Hindi teacher. So he was appointed as Hindi teacher, Nurul Amin, at the initial stage.
So that is how 3 became 4.
My lord, he was appointed at that point of time. However, on the in fact, Hindi teacher was
there are only 3 sanctioned posts.
3 sanctioned posts. So the third sanctioned post was for Hindi teacher, and this, it says 1 Nurul Amin as Hindi teacher.
Hindi teacher, you see, under the
Hindi
SS,
teacher is not a sanction, my lord.
under the
It is-
SSA
My lord,
norms,
it's
not a
written in the
sanction.
judgment. My lord, I'm simply reading the judgment.
It is not, my lord.
I'm simply reading the
My lord,
judgment.
there is a limit of, my lord, misleading the code
Come
also.
to page 45 of the state affidavit. The picture will be clear.
Please, let her finish. Let her finish. Yes.
I'm deeply obliged, my lord. However, on the resignation of Shri Abdul Ghaffur Khan, the managing committee appointed Srimati Nazila Begum as language teacher, and thereafter, on the resignation of the head teacher Shri Gyasuddin Ahmed, Srimati Shobuza Begum BSc was appointed as head teacher. My lord, Srimati Shobuza Begum's appointment was under challenge in this very writ petition, because 6 of the managing committee members out of 11.
Finish it. Let us get the.
It is to be noted that all the teachers, including Nurul Amin, had endorsed her appointment. My lord, this was categorically denied in the rejoinder. As the fulfillment of National Council for Teachers Education (NCTE) norms was made mandatory, the school managing committee of the school, in its meeting dated 6/4/2014, decided to give 3 years' time to its teachers to acquire the said qualification. Now, the qualification is DLED. As per the meeting dated 3/5/2015, it was reported that 3 teachers of the school had fulfilled the required NCTE norms, and these were Srimati Chobuza Begum, Shri Abdul Rafiq, and Srimati Nazila Begum. As recorded in the enquiry report, Shri Nurul Amin failed to acquire the required qualification to fulfill NCTE norms during that period of time and was present in the meeting dated 3/5/2015 as a teacher representative when all the decisions were taken. Thereafter, with the advent of the Right of Children to Free and Compulsory Education (RTE), the permissible number of teachers as per SSA UP school norms was 3 in number, 1 for language, 1 for science and mathematics, and 1 for social studies. The second phase, as per the report, then witnessed the origin of the controversy as Shri Nurul Amin started claiming himself to be the language teacher, the senior most teacher, and also head teacher from the year 2017. This, it appears, was on the basis of a purported approval order issued by one Shri T.S. Sangma, the then in charge joint DMC, who was not authorized nor empowered to issue the same. It is noted that in this regard, a show cause notice was issued to the said Thomas S. Sangma on 29/10/2019 by the competent authority for his illegal action. The controversy was then compounded due to the actions of another joint DMC, namely Srimati Ila Begum Laskar, who then issued orders in favor of Shri Nurul Amin, such as by declaring him to be the language teacher, apart from the senior most and head teacher. Thereafter, the managing committee with Srimati Shobuza Begum as the ex officio member convener was also dissolved by Srimati Ila Begum Laskar, and a new managing committee with Nurul Amin as ex officio member convener was approved. Though complaints were made as to the illegal constitution of the said managing committee, which was formed without a general public meeting being called, contradictory resolutions were passed by this committee, which were approved by Srimati Ila Begum Laskar in her capacity as joint DMC. As recorded in the report, Shri Nurul Amin allegedly misappropriated school funds and also deducted the salary of Srimati Nazila Begum, which compelled her to file WPC number 383 of 2017. In this period, another writ petition being WPC number 30 of 2018 was also filed for dissolution of the managing committee approved by Srimati Ila Begum Laskar, wherein Shri Nurul Amin was made the ex officio member convener. The third phase in the sequence of events commenced with the State Project Director SSA Shillong directing for a detailed inquiry about the irregularities in the school on receipt of complaints by order dated 28/9/2019 to ascertain the correct position. In the said order, it was also directed that ample opportunity to be given to all the stakeholders to file their claims and counterclaims with relevant documents. On notices being issued, all concerned respondents except Nurul Amin replied, and who, even after 3 notices were issued, instead wrote to the DMC asking for revocation of the notices, which on being refused, even wrote to the State Project Director asking him to revoke the letter dated 28/9/2019 by which the inquiry had been ordered. The inquiry authority, that is the DMC Tura, then, as no replies were forthcoming, obtained all the relevant documents from the office of the joint DMC Shri R.K. Hajong. Thereafter, a detailed report was prepared and submitted to the State Project Director SSA by letter dated 6/2/2020. As per the materials and the report, the DMC Tura, on the directions of the State Project Director SSA, then by letter dated 2/3/2020, declared that the claim of Shri Nurul Amin as a language teacher, senior most teacher and head teacher was untenable as compared to the claim of Srimati Nazila Begum as language teacher and Srimati Shobuza Begum as head teacher. However, the events took another twist inasmuch as Srimati Ila Begum Laskar, on assuming in charge as in charge DMC once again by an order dated 13/5/2021, first kept in abeyance the inquiry report dated 6/2/2020 and also order dated 2/3/2020 passed by her predecessor, and subsequently passed an order dated 4/8/2021 nullifying the inquiry report and order dated 3/2/2020. It is noted that as per the report, the said inquiry report dated 6/2/2020 and order dated 2/3/2020 as per the claim of Srimati Ila Begum Laskar was cancelled pursuant to the findings of a meeting allegedly conducted on 4/8/2021, which however was found out to be false on an inquiry conducted by the administrative officer on directions from the state project director. It is then seen that in this continuing saga, in the said school, amidst the intense litigation as per the report, and which is evidenced by material documents, a forged document, that is a letter dated 13/5/2021, was annexed by Shri Nurul Amin in WPC number 119 of 2021, which was with regard to the term of the managing committee. This was then compounded by the same document being annexed by the state respondents, which however, when the same was detected, was corrected by the government advocate, who in his letter dated 28/7/2022 stated that the same was done so inadvertently. Not government affidavit and thereafter withdrawing.
Please continue.
Obliged, ma'am. What can be gleaned from the report on the facts as placed above is that the entire dispute had arisen from the time that Shri Nurul Amin claimed that he was the duly appointed language teacher and not Srimati Nazila Begum, and further that being the founder teacher was the head teacher and not Srimati Shobuza Begum. This court has thoroughly examined the inquiry report dated 21/7/2023 and all the supporting documents which have been annexed to the said report, on which the findings have been rendered. The findings concisely put are as below. The root of the problem of the Khetadoha SSA UP school is because of the claim made by Shri Nurul Amin that he is the head teacher, being a founder teacher, and that he is also the language teacher. This controversy came about on account of the new NCTE norms that there could be only one teacher each for language, social science and mathematics. It should have been that there could be only one. When Srimati Nazila Begum was appointed as a language teacher and Srimati Shobuza Begum as science and mathematics teacher in 2010, Shri Nurul Amin never raised any grievance at that stage, and in fact on merits has no case, as he was never appointed against the sanctioned post. Now, my lord, I will come back to this later. It is evident from the circumstances that Shri Nurul Amin became active after the illegal approval order was granted by the then in charge joint DMC Shri T.S. Sangma, and when subsequently Srimati Ila Begum Laskar occupied the said post. He never responded to the inquiry to seek to establish his position. That Shri Nurul Amin allegedly was found to be embezzling SSA funds and never took any steps to reply to the allegations, and rather than reply chose to challenge the authority of the official who had instituted the inquiry, which raised sufficient suspicion as to his acts of commission and omission. The matter is all the more serious as Nurul Amin had even submitted fake documents to substantiate his claims. Shri Nurul Amin failed to acquire the required qualification to fulfill NCTE norms, and at that time when the three teachers were appointed against the sanctioned post, namely Shobuza Begum, Abdul Rafiq and Nazila Begum, he had attended the managing committee meeting held on 3/5/2015 and as a participant of the proceedings was therefore party to all the decisions taken. From the records submitted, Shri Nurul Amin attended his duties in the school with effect from his date of joining from 5/3/2010 to June 2017 and remained absent from his duty from July 2017 to 8 February 2022. Whereafter he was terminated from service on 9/2/2021. No reply was given by him nor the charges rebutted. I will come back to this as well, my lord. During the period Shri Nurul Amin was the convener member, the salaries of Shobuza Begum and Nazila Begum were deducted in an unauthorized manner, which led them to file writ petitions before the High Court, which resulted in a situation where salaries have not been paid to teachers who are regularly attending to their duties in the school. With regard to the role of officials in the education department in complicating the matters, the role of Srimati Ila Begum Laskar in her capacity as joint DMC and DMC is questionable, as she has passed many arbitrary orders favoring Sri Nurul Amin, and also her inquiry reports appear to be suspect and not in order. In the inquiry, she accepted that it was difficult for her to understand the rules. It is further remarked in the inquiry report that Srimati Ila Begum Laskar may be cautioned. Apart from the findings indicated above, the report has also noted serious areas of concern that need to be addressed, such as the manner of functioning of the managing committee and also the manner and method of selection and appointment of teachers. The Commissioner and Secretary, Education Department, Government of Meghalaya, Shri P. Bakshi IAS, as also his predecessor, Dr. B.D.R. Tiwari, it is noted, in the conduct of inquiry on several dates, had summoned all the stakeholders in the several cases that had been filed before this court, and they were also examined in person, apart from being allowed opportunity of being heard, and also for submission of any final relevant documents. Relevant documents had been submitted, including originals, for the purpose of inquiry, which was relied upon, as also the submissions and statements made by all the teachers of the school, head teacher, members and chairman of the school managing committee, officials of the education department and other litigant parties. School attendance registers, reports of earlier inquiries conducted at various levels had also been examined, and as recorded on 22nd June 2023, all litigants and concerned parties had made further statements in addition to the earlier statements and documents, apart from being subject to cross-examination on the submissions. In the considered view of this court, the inquiry had arrived at the findings as recorded in the report in a fair and transparent manner, wherein all the parties concerned were afforded adequate opportunity. In these circumstances, therefore, the report is accepted in its totality, as also the suggestions given therein, to finally give a quietus to the disputes in Khetadoa SSA UP school and to bring to a closure all the pending writ petitions before this court concerning the present dispute. As such, without lingering or dwelling any longer on the facts, claims and counterclaims of the parties individually, in these batch of writ petitions, the same are disposed of with the following teachers. First, as Sri Nurul Amin has been found not to be a teacher occupying a sanctioned post and terminated from service on 9 February 2021 as per the resolution of the same date, and further having indulged in disruptive activities such as filing of fabricated documents which has dislocated the functioning of the school as recorded in the report, appropriate action as per relevant rules and in accordance with law, both civil and criminal, shall be initiated against him, both by the managing committee as well as by the district school education officer, West Garo Hills, within a period of 8 weeks from the date of this order. Second, Srimati Ila Begum Laskar, in her capacity as joint DMC and TMC, having acted in a manner which is prejudicial and damaging to the school and the office she occupied, appropriate disciplinary proceedings shall be drawn up against her by the Director of School Education and Literacy, Government of Meghalaya, Shillong. As 3 teachers, namely Shobuza Begum, Shri Abdul Rafiq and Srimati Nazila Begum, are the rightful sanctioned teachers of Khetadoa SSA UP school, all outstanding salaries and benefits is to be released to them immediately by the school managing committee. As the RTE norms are in place, the managing committee shall be constituted as per the said norms, to be reconstituted every 2 years, comprising of 75% of the members from amongst parents or guardians of children studying in the school and 25% from elected members of the local authority, teachers of the school and local educationists. All vacancies are to be compulsorily advertised by the school managing committee and eligible candidates be selected by way of test and interview. Accordingly, as per the discussions and as ordered herein above, these writ petitions stand closed and disposed of. The report dated 21/7/2023 is made part of the records. A copy of this order to be furnished to Mr. Abraham Lerner GA for necessary action. Now, my lord, if there are certain portions on which I may be permitted to make submissions, my lord. Paragraph
What else do you want to say?
Lord, paragraph 11 of the judgment, it says that one particular document was annexed by the appellant in WPC number 119 of 2021, and the same document was relied upon by the government advocate. My lord, can an affidavit sworn by a government official be withdrawn on the verbal submission of the government advocate? Because government advocate is not the deponent, it is the official, and once an oath has been administered before a competent authority, it cannot be just withdrawn by seeing some misunderstanding. My lord, this withdrawal, it has been recorded in this particular order only.
Court allowed it to be withdrawn, isn't it?
My lord, I am not aware about that because
No, but then
this,
you're making a submission there.
my lord, my submission is on the legality, whether a government advocate can withdraw on basis of the
Well, it appears that it was withdrawn. It was allowed to be withdrawn.
it was withdrawn.
Once it is not under challenge, why should we go into those things again?
My lord. Secondly, my lord, page number 96, point number 2, it is the finding of the inquiry officer, which says that Shobuza Begum was appointed as science and mathematics teacher in 2010. Now, my lord, if I may take your lordships to page number 25, my lord. This is one of the annexures to the writ petition. It is a typed copy of the resolution of the managing committee. Proceeding, the managing committee meeting of Khetadova Upgraded UP School is held today, 28 May 2012 at 10 a.m. in the school building premises. And
25.
page 25.
Nothing like that.
It's 26. I think the next page.
Which one are you reading?
The resolution dated 28 May 2012.
Yes.
That has been done.
The resolution is at page 26. On page 25, only the name of the members are.
Opposite.
My lord, I will
25 is the
cross-
resolution and 26 is the name.
My lord, I will correct my copy from the records.
You are reading the resolution.
Resolution, my lord. The date of the resolution is relevant in this matter. The resolution date is 28th of May 2012, and I'm reading resolution number 2. As per the long discussion for the application received by the secretary of the school and decided in the meeting that Srimati, it should have been Srimati Shobuza Begum has qualification BSc passed with a qualitative 52.8% under the Guwahati University. After a long discussion, the meeting unanimously supports to appoint Srimati Shobuza Begum as a head madam of the school. So the House empowered to the secretary of the school to issue an appointment letter as early as possible and instruct to join within a short time as possible. And if I may, my lord, if I may just go back to resolution number 1 as well. It was resolved in the meeting that the House discuss regarding the resignation of the head teacher, Shri Gyashuddin Ahmed, as he get appointment as head teacher of government UP school. The House deeply think and discuss regarding the post of head teacher of the school because there were no one assistant teacher has BA passed from the staff. So, my lord, the appointment is of 2012. Shobuza Begum's appointment is of 2012. It is not of 2010, as has been recorded in the inquiry report.
No, but this is not appointment. This is only a
This is the resolution. On the basis of the resolution, my lord, it was forwarded, and at page number, my lord, annexed in your lordship's copy, I think it will be page 29, since in mine it's 28. It is a letter dated 10/1/2017. Page 28, 10/1/2017, my lord. As per resolution number 3 dated 28 May 2012 of the School Management Committee of Ketadhowa Upgraded UP School, the appointment of Srimati Shobuza Begum BSc, passed as a senior most science and mathematics teacher of Ketadhowa Upgraded UP School, is provisionally approved. My lord, the approval is in 2017. Then how can
that person T.S. Sangma, isn't it?
how can the appointment be of 2010 then? If the approval is in 2017, how can the inquiry report say that she was appointed in 2010? Inquiry report, the findings concisely put are as below. Page 96. The findings of the inquiry report have been quoted by the learned single judge. And it says that Srimati Shobuza Begum as science and mathematics teacher in 2010. So, my lord, the inquiry report, the first flaw which we can find is right here. That this is one of the
inquiry
major
report
flaws.
doesn't say that. The inquiry report doesn't say that, my lord. There is a typographical error in the judgment. The inquiry report is here, my lord. It is very, very apparent, my lord. They are saying, my lord, that Nazila Begum was appointed in 2010, my lord, and Subuja was appointed in 2012, my lord.
It appears to be a typographical error then.
There is a typographical error, my lord.
My lord, if my learned senior is relying on the inquiry report,
Did not even apply for a copy of the report. For your perusal, forget about that.
Not
that
yet,
then
my
some
lord.
remains, that
Not
has
yet,
been
my
supplied to you.
She should have applied and then she should have come before this honorable
More
court.
confusing. You see, if your contention, you raise this.
But my lord, the judgment is speaking so. I am relying completely on the judgment.
Okay, there is a
But the background of the judgment also she should rely, my lord. It's not that she will just come up, my lord. Below the oil, my lord, there is water also. She is not hitting on the waters, my lord.
I think, my lord, personal comments should be avoided in the courtroom.
This is not personal, my lord. There is nothing personal. I am saying, my lord, is that the judgment was passed on the basis of a report. Now, report is not before this. And I am just relying on the report. And then she said that if I am
She's
relying.
a colleague of yours, you see. She's a junior colleague of you. You should at least.
My lord, going further, my lord, this is my humble submission. This is not, I'm not on the grounds. It's one of the grounds, of course,
So
it
in
will
view of
come.
the typographical error, that also goes. The ground is going to go.
As your lordship pleases, my lord. It was just my
There is no
submission.
infirmity.
Next.
But otherwise, how this benefits you? You have to stand your own. What about
Yes,
your-
my
your-
lord.
your
My own
qualification?
appointment,
See, you have not till now addressed those parts
my
of
lord.
the inquiry wherein it was said that you did not have the requisite qualification. Then it said that
I can show that.
your service was discontinued.
My lord, I can show that. That is what I'm coming to. That is there in the, it was there in the writ petition records itself.
Anyway, you see, we are not going to full-fledged hearing now.
My lord. Now, my
The
lord,
purpose is only to convince the court that you have a case to be
my lord,
heard,
my lord.
which will take the matter forward. The respondents also have to be given an opportunity to be, to counter your submission.
Indeed, my lord. Coming to my lord.
And
Yes, my lord.
according to us, what we feel is since the first appeal has to be corrected as far as those papers and everything is concerned,
My lord.
and the appeal, all the three appeals will be heard, at one go.
That would be in the best interest of the
Because
school
since
as well, my lord.
Since it emanates from a common order.
My lord.
So going to this whole exercise of hearing in detail each and every
My lord, my humble submission. My lord, this particular judgment is based on the inquiry report. Inquiry report says Nazila Begum is a sanctioned teacher occupying a sanctioned post. I had taken your lordships to the affidavit in opposition filed by the state government yesterday also. And I would again like to rely upon the same, my lord. and the relevant portion of it, my lord, is typed in my rejoinder which I had filed before the learned single judge. If I may take your lordships to page number 58.
Yes, Ms. Agrawal. I think what we would like to hear the respondent is only on the issue of maintainability. If you
Yes, my lord.
you feel that you have a case on maintainability, then
Yes, yes, my lord.
as far as merits are concerned, we have heard you.
It
and
has to be heard, my lord.
perhaps the matter has to be heard.
Yes.
My lord,
Yeah,
and
many-
my no, my lord, prima
Many
facie,
issues have
prima facie,
been
my lord,
raised. Many issues have been raised.
my lord, prima facie, it is my duty to satisfy your lordships. Reason being, I am seeking for an interim protection in this particular case.
We'll look at that.
Reason being, the learned single judge, without furnishing a copy of the inquiry report, it is one of the major grounds, my lord. This is the most important ground which I have raised in the appeals.
I mean, again, you have gone on that refrain. We will look to it.
And my lord, the learned single judge has directed that civil and criminal action both need to be initiated against me. So my lord, if in case civil and criminal action is initiated against me, it will lead to multiplicity of proceedings pending the writ appeals before this honorable court. And ensuing next week, my lord, vacations are starting and we will not have a bench as regularly as we have now.
Fine.
So
We have heard you.
the appellant will be caused grave prejudice. And secondly, Srimati Nazila Begum was stated to be a non-sanctioned post teacher by the state government in the affidavit in opposition, that too in a case which was filed by Srimati Nazila Begum. Same, Nazila Begum had filed the writ petition. Government has stated that she was occupying a non-sanctioned post, and that is why she does not deserve to get the salary. It is a part of the record. Now, my lord, the impugned judgment directs that Srimati Nazila Begum should be paid the salary. Secondly, with regard to Shobuza Begum, I had challenged the very appointment of Shobuza Begum. The appointment of Shobuza Begum, my lord, it has been vaguely addressed in the judgment. I will get more time and I will come more prepared before your lordships with regard to the inquiry report, how much in depth they have gone with regard to Shobuza Begum. But as on date, my lord, the list is still pending as regards the legality of appointment of Shobuza Begum, since I have already preferred the writ appeal before this honorable court. Because the only prayer in this writ petition was to set aside the appointment of Srimati Shobuza Begum, because the 6 members, the appointment was made in a very, very malafide manner. No advertisement was issued, and the managing committee, which is the appointing authority, 6 members out of 11 members comprised of the relatives of Shobuza Begum.
Those are all, you see, argument on merits.
My lord, that is a resolution of the managing committee. So, my lord, in such circumstances, if salary is paid to the other private respondents, Srimati Nazila Begum as well as Srimati Shobuza Begum, then I will also be deprived of my salary. Reason being, I have been working continuously. And the item number 3 before your lordships today, in that particular writ petition, I had made a prayer for release of my salary with regard to a particular period. So, my lord, I will also, recovering money from them will not be as simple as it seems. It's not a government authority or something. It's a private individual. So, my lord, once the salary is released, I will be deprived of it. If civil and criminal action is initiated against me, it will lead to multiplicity of proceeding. Subsequently, if in case this writ appeal is allowed, then again another round of litigation will start with regard to withdrawal of or refund of the salary from Srimati Shobuza Begum and Srimati Nazila Begum. So, my lord, these are issues which need to be dealt with at one go. That is why my humble prayer is, my lord, any date. It may be immediately after the vacation also, my lord. Reason being, this matter pertains to a school and we are dealing with the life of students. So, any date immediately after the vacations may be fixed. We will come prepared and the hearing may be taken on the first day itself. I will not seek any adjournment. It can be recorded as an undertaking as well.
Yes, Mr. D, what do you have to say?
My lord, I have few submission to make. First and foremost, my lord, it's nothing personal, my lord, with my learned friend. a junior colleague of mine, where we appreciate she has addressed this honorable court for such a long time, and she has taken to those papers also which are not relevant, my lord. Now, my lord, may I kindly see that order that I have supplied to my lord. Order dated 7/2/2023, my lord. Now, my lord, may kindly see in the second page, para 2. In fact, said inquiry was gone into, my lord got it, into on so and so date, so and so date, so and so, and so and so. It is noted that the last report dated so and so, by which, my lord, this Nazila and Sobuja was removed and their salary was stopped and all. The managing committee was removed, my lord. The district mission coordinator, West Garohis Tura, had rendered finding on the status of the teacher apart from challenging the earlier report. However, this report was also put to challenge. This challenge was done by us in that writ petition, and that writ petition is not under challenge, my lord, before this honorable court.
What petition?
In the common judgment, my lord, 464, my lord, writ petition number 464, my lord, that is not under challenge before this honorable court. And we have challenged this inquiry report. That is not under challenge. Now, my lord, my learned friend was
464 appellant is a party.
Sorry, my lord.
In 464, appellant is a party there.
Yes. No?
Yes, my lord. Mr. N. Singhon was appearing.
Managing committee, and yes. Now, my lord, what my learned friend has submitted regarding this order, my lord, 7/2/2023. I will request that my learned friend should not submit like that, my lord. Just a minute. My lord, may kindly see the first page where the parties' names are reflected. Now, my lord, may kindly see the petitioner name S. Marpanar, vice Mr. S. De. For the respondent, H. Abraham, for the government advocate for respondent so and so, Miss Pooja Agarwal so and so. She just submitted, my lord, that she was not aware of this order, my lord. She was present in the court.
It's all right.
No, my lord, but my lord, someone submitting before this honorable court, my lord. We are the officer of the court, my lord. We should do our best to give the best, my lord, here. It's not that, my lord, we should mislead, my lord, when the matter of record is there.
The court passed several orders.
My lord.
We are not expected to know by heart each and every order.
No, my lord. What my learned friend has submitted, that she is not aware of this order, my lord. The order was passed in an open court, my lord, this order. Now, my lord, may kindly see Nazila Begum. She has submitted all out, my lord, in connection with Nazila Begum. Now, Nazila Begum is the writ petition, writ appeal number 50, my lord. That cannot be taken up because it is not filed, my lord, as per the Meghalaya High Court rules, my lord. Second thing, my lord, she has submitted everything, my lord, except, my lord, that forged documents submitted by her. She has not said anything. She has not addressed this honorable court. By him. I'm sorry, my lord, not by her. By him. She has not addressed this honorable court. Now, my lord, a person who goes to the inquiry, my lord, he had every chance to cross-examine, and he has cross-examined also, my lord. My lord, may kindly see the order which is impugned before this honorable court. Now, my lord, may kindly see page 100, my lord, of the memo of appeal, my lord. Made further statements, the first line, my lord. Made further statements in addition to the earlier statements and documents apart from being subject to cross-examination on the submission. That means they had a chance to cross-examine and they have represented their case, my lord, before the inquiry commission, my lord. Now, my lord, why this inquiry was called for? Because there was 4 inquiry, my lord. There was a claim and counterclaim.
And because they participate,
my lord.
Will it mean that they cannot challenge that report anymore?
No, they can challenge, my lord. We are not saying that they cannot challenge it. They can challenge. Now, my lord, if, my lord, interfere with the order of this honorable court of the learned single judge, but the report will remain. The report is not under challenge. It is not that, my lord, the report has merged with appeal, my lord, with a single judge order, my lord. The report also has to be need to be challenged, my lord. What best my learned friend could have done, my lord, she could have.
But that report was the basis for this impugn order.
Yes, my lord. But if the order goes, but a report cannot go, my lord, because the report is not under challenge. This is my understanding, my lord. I am open to be corrected, my lord.
I don't understand your logic.
What the best my learned friend could have done, my lord, she could have challenged the report, my lord. Challenged the report before the learned single judge. And after filing the appeal, my lord, she could have tagged both the matters.
When the appellant is not aware of the report itself,
That my lord,
that is what has been submitted.
submitted, my lord, with due respect, my lord, if I can get a copy, my lord, why not appellant? Now, what was the base of his claim, my lord, before this honorable court, before the learned single judge? The very base of his appointment, my lord.
Mr. D, just a
My
moment.
lord.
Can you tell us from the records, when was the report taken cognizance of by this court?
My lord, this is, my lord.
Obviously, it should be before the impugn order was passed.
Yes, my
It
lord.
should have been in the order sheet that such and such report was filed.
Yes, there is there, my lord.
July, my lord.
July.
21st July 2023.
Yes, my lord.
There was an order.
There was an order. There was an order.
At that point of time, you're aware that there's a report filed?
The report was there. We prayed before the court that a
achha.
copy of the report may be
it was
provided to us. But the court told that we will first go through the report. If we find it necessary, then we will provide it to you on the first occasion. The second occasion, when we
These
sought
are
for
the
the report again,
orders, my lord.
Yes. We got your point.
You were present on it.
yes, my lord, I was very much present.
Around 9/8, my lord, the inquiry report was taken formally into the board, my lord. And she was present, my lord.
Yes, my lord, I was present on every date. And I had prayed for a copy of the report.
That has not been recorded, my lord.
That is what, my lord. That is the whole point.
We don't know, my lord, whether the submission was made or not. I was not there on that day, my lord, so I cannot say also.
My lord, in fact, throughout the proceedings, almost on every single date, Mr. S. Deb was appearing on behalf of Mr. S. Deb. Throughout the proceedings.
So nobody can watch that for you that you have made a prayer before the court for.
My lord, I can, there is, if Mr. N. Sinkon would be inside the courtroom right now, or Mr. K.P. Bhattacharjee, or Mr. H. Abraham, they all will say that I had made that prayer, my lord.
Definitely not.
They
Now they
all
are
were
government
there.
side, my lord. How they can say that?
My lord, as an officer of the court,
To record your submission, isn't it?
my lord, it was not recorded.
Ultimately, it comes to that.
It was not recorded. But my lord, your lordships will appreciate one more aspect. Your lordships will also appreciate one more aspect. I'll take to another case. We are having the suo motu coal mining case. On every occasion, a new report is submitted by Honorable Justice B.P. Kataki. And after any report is submitted, it is stated that a copy of the report to be furnished to all the stakeholders in the matter, and they are to respond if they have any submissions. It is being done. So, my lord, that is also a report on the basis of the order of the court, and this is also a report on the basis of an order of the court. So, if I am being prejudiced by the report, am I not supposed to be heard, my lord, before the judgment is rendered? Even if I don't pray for a copy of the report, assuming that I did not pray, even if I don't pray for a copy of the report, does it mean that it disentitles me from being heard on the inquiry report if it is against me?
In view of no submissions made on behalf of you, which a court could have presumed that you needed a copy.
My lord, the very logical thing, Mr. S. Dey's colleague was very much in the courtroom. If the court would have furnished the report, it would have furnished to all the parties. They are also party to the proceeding.
You also could have specifically paid for it.
My lord, I had specifically prayed for it. I cannot compel the court to record something what I say.
You could have filed a petition asking for that.
My lord, may kindly say,
I
my lord.
cannot compel recording of submissions.
This was taken on board on 9th August.
My lord, verbal submissions are there.
And you remained silent.
No, my lord.
My lord.
The court passed the judgment.
No, my lord. I did not remain silent.
My lord, may kindly appreciate.
What you did?
My lord, we had made oral submissions
Or you were
even
sure
on
that
the
this
date of
report will be
pronouncement.
in your favor?
No, my lord. In fact, from the manner in which the court was saying that who is Shri Nurul Amin, we could understand that there is something adverse in the report. That is the whole reason we wanted to see what is there in the report. If there is something adverse and if it is...
You could have applied for the copy of that.
Oh,
There is no.
my lord.
And if the court does not give permission to furnish a copy of the
You
report,
did not ask for the permission. Where is that?
my lord, we did seek permission, my lord.
My lord.
My lord, as an officer of the court, I will definitely not mislead this honorable court and come on such grounds. I'm not accusing any court, my lord. But the fact is, if something is adverse to me, I need to be heard before passing of a judgment.
Definitely. So to find
My
out
lord.
So
whether
that
they are
judgment,
My lord, may
that,
kindly
that
appreciate.
report was not there with us.
So just to
My lord, may kindly appreciate. This report was taken on board in the month of September, my lord. And the judgment was passed in the month of November, my lord, 24th November 2023. Now, if my learned friend already got a hint, because there is an allegation now against the learned single judge also, that he commented something. I don't want to comment on that,
He
my
did
lord.
not comment. He just asked, who is Shri Nurul Amin? This is the
So she
categorical
got an
question.
indication. She got an indication. She could have filed a miscase, my lord. I'm bored now.
we have that in single bench record, yeah? Just give us the order sheets.
Where is the 29th August? And next order of this one. Was there a hearing on 29th August? That's what I asked, what is the date?
29. Yes, my lord. It was a short hearing. Matter has been taken up today for hearing, as the same is substantially heard on the last occasion.
From order, there is a
Yes, my lord.
20.
29.8, my lord.
yeah.
Not a full-fledged hearing did not take place. We all were present.
We're just trying to look at the,
My lord.
the respective orders.
29th August was the last date.
So there was a hearing after the report was.
Yes, yes, yes.
No, my lord. Sorry, I beg to differ, my lord. After the report was submitted, first it was not flag marked. If I may use my phone, I'll see the order sheets and I can recollect.
So what order? The low court records are here.
Both proceedings are conclusive.
What should we?
You are present, madam.
Yes,
on
my
the day
lord.
of hearing,
Yes,
and
my
you
lord.
will
I
not-
was
you will-
present.
See,
And-
submission which is supported by records. If you say something which is not supported by record,
Digital records, that is
see,
why it's being
it
maintained.
says hearing concluded, judgment reserved, and you appeared. You are hearing this.
Yes, my lord. I was
Don't
present
say
in the
that
courtroom.
It was a short hearing, long hearing. You see, one thing is attainable that you were heard after report was done.
My lord, we simply prayed for a copy
you
of
are
the
a-
report.
You know, you are a seasoned counsel. It is not that you are appearing for the first time before.
Lord,
You know what submission to be made and what not.
Lord, hearing was duly conducted, but after the inquiry report was submitted, on the inquiry report there was no hearing. On the inquiry report, because my lord, the inquiry report was never provided only.
There is nothing recorded that you had any objection with regard to the conclusion of the hearing and reserving it for judgment.
Lord, as your lordship pleases. That this is my humble submission. This is my ground. Inquiry on the inquiry report, we were not heard.
This is 51
51. my lord.
and 52.
My lord, 52, I was claiming salary. My salary has been denied by because the report says that I was not a sanctioned post teacher.
no
But I
substantial-
I can prove it from the records. In this particular writ petition itself, I had filed a rejoinder because, my lord, my writ petition was that I was challenging the appointment of Shobuza Begum. The state government filed an affidavit in opposition contending that my appointment was irregular. Without responding on how Shobuza Begum's appointment was made, nothing was addressed on that particular issue by the state government. And Srimati Shobuza Begum submitted before this honorable court that they will be relying on the affidavit filed by the state. So the state had filed an affidavit saying that my appointment was irregular and it was not done in a proper way. As such, I had filed a rejoinder, my lord. My rejoinder is at page 50. 50. At page 50.
51? 51?
50 it starts in my record. And all the documents pertaining to my
One second.
well,
What is page number?
50, she's relying on this rejoinder.
What? This is 52.
52 or 51? This one?
this is writable 51.
51.
In 52 there is no affidavit.
Still for language teacher. No such place. Still for language teacher. Still language teacher.
Fake document is 35.
Okay.
35
My lord, I was addressing on that particular
Fine, I
point.
think
What about
we have heard you.
my qualification?
We have heard you.
My lord.
We'll admit the appeal.
May I make a submission?
There are too many,
Lordship,
issues
may I
with
make a
this
submission, Your Lordship? Lordship, in my humble and respectful submission, Your Lordship, these appeal are not entitled to be admitted, Your Lordship. This is my humble and respectful submission, Your Lordship. Lordship, a proceeding under 226, Your Lordship, is an equitable jurisdiction, Your Lordship. A person who comes to the court, Your Lordship, should come with a clean hand. A person who comes with tainted hand, Your Lordship, a relief should be refused immediately, Your Lordship. Outrightly, Your Lordship, I will submit, Your Lordship. Lordship, if I'm pleased, Your Lordship, there is a one writ petition that is 456, Your Lordship, of 2021, Your Lordship, filed by one.
Is it under appeal here?
No,
No,
my
Your
lord,
Lordship.
456, if I'm not wrong, was
This
it
is a
was
common
rendered
judgment, Your Lordship.
infructuous.
It is there in the common judgment, Your Lordship. In that case, Your Lordship, one Johan Ali, he filed a writ petition challenging the cancellation of the managing committee, Your Lordship. What happened, Your Lordship? The state government filed an affidavit that is enclosing one document 13/5/2021, which is a fake document, Your Lordship. The writ appellant, Your Lordship, taking advantage of this fake document, Your Lordship, he filed 119 of 2022, Your Lordship, which is before Your Lordship appeal.
No, what?
119, no? 119.
No. 119 of 2021, I have not filed any appeal, my lord.
No, a writ petition. You filed a writ petition.
Writ petition must have been filed.
119 of 2022. Taking
Sir,
advantage.
Sir,
Please,
it's
please
before your
finish it.
lordship. That's why I'm just clarifying.
It's,
that
I
there's
think
no writ appeal.
it is part of the impugn order.
Ma'am.
If the impugn order has taken into consideration all these writ petition, then
Lordship, then taking advantage of this fake document, Your Lordship.
We'll hear you on the next time session.
Lordship, my humble and respectful submission, Lordship, this appeal should be rejected outrightly, Your Lordship. A person, Your Lordship, filing a writ petition, Your Lordship, annexing a fake document,
See,
a
Mr.
forged
Shura,
document, Your
even
Lordship.
that-
Whether Your Lordship will keep
even that issue has to be heard. Now we cannot just heard you.
Lordship, I'll point out, Your
just
Lordship. Because the
That is not-
documents,
that-
the
that-
documents of
but that is
13.5, Your Lordship, what it has been done in a very xeroxing of that
could be.
order, Your Lordship. It has been done in a very most probably by an expert hand, Your Lordship. Because the memo number, Your Lordship, of that order is same with the genuine one issued by the government.
Is that part of the proceeding?
Yes, Your Lordship.
Yes,
Your
reflected
Lordship.
in the impugn order.
Yes, Your Lordship. It is here, Your Lordship, part and parcel of all this. That is why, Your Lordship, the learned
But
single judge.
if that portion has not been challenged, by the writ appellant or by anybody for that matter, it goes.
Yes, my lord.
It
Nobody
stays
has
on
challenged.
record. It stays on record. So to that extent, the impugn order, will stay.
We'll attend the finality, my lord. Then.
Yes, as you say so, it'll attain finality.
Beg a pardon, Your Lordship.
To that extent, you see, as far as your submission is concerned, if there has been an observation of this court that such fraud has been committed or forgery,
Yes,
whatever,
fraud. That's why, Your
and
Lordship.
there is no challenge to it.
Yes, Your Lordship. No submission has been advanced on that, Your Lordship.
One-
That's why, Your Lordship.
the writ- see, the appellant-
the learned
appellant-
single
see,
judge,
the
in the
appellant-
wisdom, in the wisdom of the learned single judge, Your Lordship. That is why.
Mr.
That's why,
Shulai,
Your
just
Lordship.
hear us. The appellant has not come before this court on account of that writ petition or that observation. He has come on different ground.
Lordship, that the report of the inquiry has not been furnished, Your Lordship. It reminds me, Your Lordship, of a buffer scandal, Your Lordship, where the government of India submitted the report, the file in the seal cover, Your Lordship. And the
We are not going to
Honorable
that
Supreme
issue
Court
because
accepted.
we are not going to that
in this
issue.
case also, Your
The
Lordship.
Supreme Court-
This Lordship, kindly see, kindly
Supreme
appreciate,
Court
Your
has,
Lordship.
Mr. Shulai-
This is a court-appointed
Mr.
inquiry,
Shulai,
Your Lordship.
The Supreme Court has time and again observed as far as seal cover issues are concerned. There's no more seal cover issues now. before court.
But in
Everything has to be transparent.
Lordship, buffer scandal, Your Lordship, that has been
gone.
has been accepted, Your Lordship. Lordship, kindly appreciate this is a court-appointed inquiry, Your Lordship. A court-appointed inquiry, and it was submitted, Your Lordship, by the inquiry officer in the seal cover, Your Lordship.
And it's up to you. We'll admit the appeal.
But protection may kindly be granted.
Lordship, if Lordship is pleased to admit the appeal, Lordship, no interim order
My lord,
should
the
not be
entire
passed.
writ appeal will become infructuous if I am not
Then so
protected.
be it. What to do?
My lord, may kindly appreciate
Let the law take its own course, Your Lordship.
the matter of becoming infectious doesn't arise, my lord. The matter will be decided, my lord, by this honorable court.
Lord, it will lead to multiplicity of proceedings
That
here
she
and
should
there.
not bother. We are ready to face her. My lord, may kindly appreciate writ appeal number 50, my lord.
No, that has to be.
No, not corrected, my lord. That cannot be corrected, my lord.
An additional affidavit can be filed bringing
No,
on
my lord.
record that particular
That
pleading.
There is no such provision. Let us show the provision by which she will file. What I am saying is this, my lord. That case she has to need to withdraw, my lord, and then she has to file afresh, my lord.
Lord, I may
She
be,
cannot correct it, my
I may be
It is not a
permitted to
typographical error
amend.
that she will correct, my lord.
My
And
lord,
documents.
it's not that I'm changing the grounds.
Can be corrected. Why not?
It's
But
a
you
technical
incorporate
error.
those documents. Why not?
It's just enclosing a
It is not
document.
something incorrigible.
No,
It
but
will not cause any prejudice to you. Why not? She can definitely incorporate it and correct
I'll
this.
file an amended memo of appeal.
yeah, let her do
So,
that. Let her do
amended
that.
memo of appeal. I'm not saying additional affidavit or something. Amended memo of appeal at the time of hearing also it will be convenient.
Filing a
My lord,
fresh
at the
and
time of
amending is same thing.
my lord, it will be the same thing. It will be more expensive for me also, but then it will be convenient at the time of hearing to refer.
Then you withdraw, file a fresh.
My lord, I may be,
Go for amendment.
my lord, let it not be withdrawn. I may be permitted to file a amended memo of appeal. Or if your lordship says additional affidavit, I can bring it by way of additional affidavit.
For filing an
How can
amended, my lord, she need to file an application for amending. That has to be allowed.
My lord, oral prayers are allowed.
No, oral prayers, my lord. She said that she has made hundreds of prayer people than a single judge. Nothing has been recorded, my lord.
we'll record the submission. Oral prayer are always allowed.
But my lord,
It's a 1 point prayer.
before my learned,
This is not a district court where for every small thing we need a petition. It is a court of record.
my lord, just I'm putting a vision to myself, my lord. The basic foundation of her case, my lord, is her appointment letter. She has fabricated an appointment letter, and now, my lord, she is coming before the division bench of this honorable court, my lord, and saying that is here. The basic thing, my lord, which is required to prove her innocentness, my lord, is her appointment, and that appointment letter was fabricated, my lord. It was forged, my lord.
You can raise all those things later. The court passes order and then see it at the next.
Well, those are photography.
Heard Mr. P. Agarwal, then a counsel for the appellant. Also heard Mr. S.G. First we'll start.
In which
Or yes.
50, what is your prayer? You'll correct it? Or what?
50, my lord, as your lordship directs, either additional affidavit or amended memo of appeal.
What is
As
the
your
objection
lordship
taken
directs.
on incorporation of certain documents? This is the only objection.
Yes, my lord, only that affidavit, incorporation, that is all, nothing else.
This is 50, isn't it? Who are the respondents here?
50 you will bring into records those.
Yes, my lord. The affidavits which I have missed out. I'll check from the original records.
In 50, who are the respondents?
My lord, Mr. SD is for respondent number 1.
Respondent number one.
And so far as state is concerned, my lord.
That is also the
My lord, state is respondent number 2 and 3.
4 is the managing committee.
4 is managing committee, my lord. I am informed that at present there is no managing committee which is functioning in the school. But since the managing committee was a party to the writ proceeding,
Yeah. Katukai, Maunum. The Learner Council has submitted that a common order dated what is it?
24/11/23.
24/11/2023 was passed by the learned single judge of this court in about 1, 2, 3, 4, 5, 6, 7 writ petitions, for which 3 separate appeals have been filed before this court. However, as far as the first appeal is concerned, that is WA number 50 of 2023. Well, seen caveat petition number so filed by the respondent number 1 in WA 50. Mr. SD has appeared for the caveator. The same is accordingly discharged. Oh no, kuno to yang to last line. Last line ne? Thang last line. Em ka last line ne? As far as writ WA number 50 is concerned, an initial objection was raised by the respondent number 1 as to the extent that the said memo of appeal is incomplete, as certain relevant annexures have not been incorporated in the said memo of appeal. Reference has been made to rule to rule 4 of the rules of the High Court of Meghalaya 2013. In reply, the learned counsel for the appellant has submitted that the appellant may be allowed to file, or rather to incorporate the said required annexures by way of an additional affidavit. Same is allowed. Same is allowed. Accordingly, the appellant is directed to bring on record the said missing or in missing annexures by an affidavit. Thereafter, the appeal will be taken up for admission. Next. In 51, any caveat?
Yes, my lord.
Yes. Then I don't see that it will be charged.
Okay, fine, we'll correct that then. Because there's, in the third one, there's...
In the third one, there is no caveat, my lord. There is no private respondent as well.
Only the state.
Only the state.
Next. As far as WA number 51 and 52, as far as 51 is concerned, where's 51? As far as WA 52 is concerned, 51 is concerned, the respondent 1, 2 and 3, the state respondent 1, 2 and 3 have been represented by Mr. Andy Shulai, learned AAG, who has accepted notice.
Said in no country of lordship.
No, the state, he has entered appearance.
Lordship.
As far as respondent 4 is concerned, Mr. SD, Land Council, has accepted notice. And as such, no notice is required upon the respondents in this matter. Only one. 52 only the state respondent.
Yes, my lord.
As to WA number 52, there's only one respondent, that the state respondent.
Two respondents are there, my lord. Both are represented.
There are two respondents. All the respondents have been duly represented through Mr. Indishwar, learned AG. Here too, no notices formally required to be issued. This court has considered the submission made by the parties, and accordingly is of the opinion that the appeal has to be heard. Matter is accordingly posted for hearing after vacation.
Apply,
My lord, I pray, my lord, it will really cause serious prejudice to the appellant, my lord.
Concern, your lordship.
Serious prejudice, my lord. civil and criminal action has to be initiated within 8 weeks. That is the direction of the learned single
The
judge.
direction is not
The-
only against
the
the appellant,
appellant-
against the state official also, Your Lordship.
My lord, the appellant
Again,
will
the
be
state official,
gravely
Your Lordship.
the appellant will be gravely prejudiced because not only civil and criminal action will be initiated against him, he's not getting any salary for the past 2 years, my lord. His father has recently been operated at Gwalpada Hospital. My lord, it will really render injustice to him, my lord. Grave prejudice, my lord. Otherwise, I would not have pressed so much.
Let us do the hearing, my lord, final hearing on 19th, my lord.
Lordship, yes.
19. If
My lord,
Let's have
19,
on 19, Your
my
Lordship.
lord, 19 and 20, the courts are about to close. It
Then
is,
what?
and I will not get the inquiry report by tomorrow. It will take some time, my
I will
lord.
give a Xerox copy to her, my lord.
My lord, it will take some time. I need to file the additional affidavit as well.
Just a moment, just a moment.
Filing of additional affidavit will also take some time.
No, I think no interim.
Obliged.
You take a chance.
My lord, deeply obliged, my lord. Item number 4.
Any observation?
Number 1.
There are 3 issues, my lord. I put the respondent, my lord. There are 3 issues with this appeal, my lord. Firstly, my lord, the original writ petition was of 50 pages, my lord. That was for the learned single judge. My counter affidavit was 57 pages, my lord. So total should be 107 pages. Now here we have 800 something pages of paper book, my lord. All additional documents which were not part or how they've come, my lord. From 100 pages, the paper book is 800 pages now, my lord. Secondly, my lord, my affidavit that has been annexed, my lord, the important annexures have not been annexed, my lord. So that will be the deciding factor in the matter, my lord. And thirdly, my lord, during the contract has already been awarded to a contractor, my lord, and he is executing the work. He is not a party before your lordship, my lord. So now, my lord, any consequences, any order passed by this honorable court will have direct effect on the contractor, my lord. So, my lord, the third issue your lordship may take up later, but first they have to rectify the paperwork.
We come back to the rule that we had.
Well, it's without even having make any reference to the rule. My learned friend had flagged this issue, Millet, regarding the paper book. We'll have it sorted out, Millet. I don't think we need to burden your lordships with that.
First of all, this was raised right from the time it was listed, but it should have been corrected by now.
Well, it's I was not aware. Millet. We'll
You have come entered there, but then you are supposed to be aware before you.
well,
As paid for by.
I was myself puzzled, Millet, the sheer size of the paper book.
So you do that then.
We'll have it sorted out.
Paid for by the parties. This is matter to vacation.
Item number 2. Tuesday. I'm not here to
Deep.
Daily.
On the last occasion, there was an additional.
We are on this 281.
281, my lord, they had filed an additional affidavit by the government, bringing on record 2 or 3 notifications. I'm filing an reply to that additional affidavit because a ground has been raised that our grievances have been redressed. How it has not been redressed is what I'm filing an affidavit today, my lord. Lordship would have that on record on the next day. The other writ petition, my lord, item 3, the other 360, 360, my lord, I have received the affidavit in opposition. I am also filing an affidavit in reply to that. Perhaps what the government has taken up the case that it was not what was not permitted by the Honorable Supreme Court to be on the remand back, my lord. That I would like to point out a few things which can be actually taken up by this Honorable Court, even if we go strictly by the orders of the Honorable Supreme Court. So just please some time, my lord. One of the affidavits I am filing today itself in 281 and 360, my lord, I'll require a day or two.
Lordship, in 360, I'll be also filing additional letter. I'll be also filing on it.
Who has filed in 360?
In that, my lord, the government state has filed.
State has filed.
You'll file
Because
rejoinder
in
to that.
360, my lord, our ground was that if the CPF does not apply to originally in the writ petition itself, our ground was that if the CPF does not apply, then the EPF comes in. So therefore, her reply, the EPF part reply, my lord, if it is on record, it will be easier for me to tackle the matter, my lord. On 281, I'll file I am filing a reply today itself, my lord. Yes, yes. That is what I submitted.
Yes. What Mr. R. Mirinda, counsel for the petitioners. Who has submitted that as far as WPC 281 of 2017 is concerned, the affidavit filed by the state has been received, wherein relevant notifications have been incorporated therein, have been annexed therein. To this, the writ petitioner, to this, the petitioner association would like to file a rejoinder, for which some time is prayed for. Next, as to WPC number 360, the learned counsel for the petitioner has submitted that he may be allowed to file a rejoinder to the counter affidavit filed by the state respondent. Pray aloud. Ms. P. Bhattacharjee, learned counsel appearing for the respondent number 3, has sought for some more time to file the counter affidavit in this matter. Pray aloud. The parties are to take necessary steps as directed. This is matter of publication.
One submission, if I am permitted to make, my lord. Our initial grievance in 281 was that our CPF money is deposited in saving bank's account and not on the fund. That is yet to formalize, my lord. It is still being deposited only in the saving bank's account. Perhaps if the government on the next date comes up with some report as to how they.
But that, you see, then we'll have to look into the affidavit filed by them. We'll have to hear them.
Then let my reply be on record, because that is
reply first, then everything can be taken out in
better
one
go,
go.
my lord, yes.
But that will be only on the only
That is the only
as far
part.
as interest is concerned.
The interest, but it has to go into a particular consolidated fund. That is the only
But
part, my
you
lord.
see, even if it goes to a saving bank's account,
My lord.
the interest accrued will still be given to you.
The interest, it comes back, but then the even the contributory part The 8% and the 10% part that remains, my lord. If it goes into the consolidated fund, we get our 10%, my lord. 2% more on the very contribution part.
So we'll see
Those
on the
issues.
next date and see how it goes.
I'm obliged.
supplementary cause list, item number 1 for pronouncement of judgment.
I'll just read out the operative portion. Mr. Debnat, there's too many disputed facts are involved here. At this juncture, this court is of the considered opinion that it would be proper for the petitioner to file a representation before the school authorities as well as the government authorities connected with the affairs of the school to seek clarification as regard the computation brought out by the school authority and also the reference to the various sanction orders issued by the government, particularly the Inspector of School, West Garo Hills, Tura, as far as the petitioner herein is concerned, since apparently there appears to be available two sets of figures or amount which could not be determined by this court in this petition without verification of the relevant documents and records. As far as the prayer of the petitioner is concerned, the order dated 14/2/2014, passed in WPC number 137, SH of 2010 has been duly clarified herein. As far as the controversy as regard the amount of 37,500, the petitioner is at liberty to pursue the matter with the authorities concerned as observed herein above. In view of the above, this petition is hereby disposed of accordingly. We approach the authorities concerned and they will clarify whether, you see, that's only with regard to the sanction order, because this court cannot decide whether those sanction orders are, are genuine or not, whether they concern you or not. But you will get your relief. Thank you.
May it please your lordship. Sir, I'd like to mention one bail application for tomorrow, my lord. There's an urgency in this matter.
Bail matters, okay.
Lord, besides that, there's another prayer, similar prayer for listing of a writ petition, my lord, tomorrow. The urgency here is, my lord, some kind of an order has been passed by the Executive Council of the District Council, my lord, which is, my lord, dehouse the rules. And my lord, given the fact that we are closing, we are just few days left for the closure of the court, my lord. There's some kind of an urgency in this matter.
What is it? It's just a matter of days. You see, let the
or else on Monday, Tuesday, my lord.
Let the competent court take some. Tuesday. And
bail application for tomorrow, my lord.
Bail application.
My lord, sorry, one more thing, my lord. This matter where I'm preferring a bail application, my lord, is in connection with item number 7 today, my lord, which is fixed today, hearing list. So I'm making a further prayer, my lord, let item number 7 also come up tomorrow, my lord. Just making a mention of
item 7 is the appeal.
Bail in that very case, my lord.
Item 7 is appeal. Are you praying for suspension of sentence?
This appellant is undergoing sentence, my lord.
Yeah.
And he has suffered some kind of a stroke yesterday, heart attack, I think, and he's in ICU right now. Just to that limited extent, my lord, we are preferring a bail application.
We will look into it.
Obliged.
I took a 7 on prayer made by the parties. This is matter tomorrow.
I beg to make a mention of item 8, my lord. 8 of the hearing.
Lordship, they were supposed to file the written argument, Lordship.
My lord, here, my lord, the written argument is ready. My lord, I can file it, my lord, if not today, by Monday, by Tuesday, I'll file it.
Is there any urgency in this matter?
No urgency, my lord. Matter was finally heard. No urgency as such.
This is after vacation. I don't want to keep judgment pending.
My lord, okay.
Your Lordship actually concluded, we've already filed a written argument also since 1810.
True, but they have taken time.
My lord.
Perhaps they know they are on a sticky wicket. We'll look into it.
Well,
On premise by the respondent, still respondent. This is matter of publication or not objected to by petitioner.
Please, Your Lordship, I beg to mention item number 9. The senior counsel is indisposed, Your Lordship.
Who's appearing for the
We've already informed the other side.
you inform? Yes, Miss, you are in this case?
For the respondent.
On premise by the petitioner, this is matter of publication.
Highly obliged, Your Lordship.
Excuse me.
Please, Your Lordship, I beg to mention item number 10. After
10.
petition, yes. Item number 10.
You're for?
I'm for the petitioner.
And for the cantonment responding, Your Lordship.
Or cantonment?
Yes, Your Lordship.
On premise by the petitioner, this is matter of publication.
Highly obliged, Your Lordship.
Let's bring to number 12, my lord.
I'm appearing for respondent number 1.
Has this matter been heard?
No.
What is the issue about?
It's deferring of cross-examination, my lord.
Oh,
Our
okay,
application
okay,
of it's allowed.
But whatever the case may be, I think the matter is proceeding or has proceeded. And you're seeking to defer the cross-examination.
We had sought and the application had been allowed, deferring of certain witnesses, cross-examination of certain witnesses. They have come against the order, allowing the application.
Then, through passage of time, don't you think the matter would become eventually infructuous?
There's a long list of witnesses. Perhaps that's why they're taking a chance.
On premise by the petitioner, this is matter of publication.
Obliged.
Supplementary cost list, item number 2.
Your Lordship, the matter has, can kindly pray that the Lordship will be enlist the matter tomorrow as the conducting counsel is out of station, Your Lordship.
What is this matter about? You are there.
Mr. N. Mansuri, Your
Let
Lordship.
us see what is this.
Lordship, since the conducting counsel is out of station, Lordship, it's an NDPS matter, my lord.
What is the offence alleged? 21C.
Yes, Your Lordship.
Then you come prepared with an answer to section 37 and then we'll see. Pre-made by the parties, let's this matter tomorrow.
Much obliged, Lordship.
Pre-made by the petitioner.
Legal cost list, item number 1.
Yes. Who's for the
Mr. Sheikh.
Oh, you are there.
My Lordship.
Yes, please.
Lordship, it's that matter, it had come up on the previous occasion also with regards to my arms license which has been suspended. Now, Lordship, I have been a police officer. I have served for over 36 years. In service, I'm an IPS officer. I'd also hold the post of Director General of Police Meghalaya, among other appointments. Lordship, the license under concern, being Annexure 1 at page 15.
Yes.
Lordship, it was first issued to me on the 20th of October 1998 and it was periodically extended as is mandated by the law, and it was last extended up till the 31st of December 2021. Lordship, on Annexure 2, page 16, on the 19th of May,
Yes.
when I had put in my license for renewal, on 19th of May 2023, Lordship, I received a letter from the District Magistrate. If I may, Lordship.
Yes. 19th May.
19th of May 2023, Annexure 2, page 16.
Yes.
With reference to the subject cited above, as per police report received that you are involved in Rinja PS case number so-and-so under section so-and-so, therefore under section 14.3 of the Arms Act 1959, read along with section 17.3b of the Arms Act, it is required that you deposit the arms weapon at your respective police station. The license will be temporarily suspended pending the decision from the trial court. Renewal of your license is subject to after cases are dropped dismissed by court. Now, Lordship, primarily I do not have any case under 302 which has been labelled against me.
Okay.
I am charged under a case which was filed by CBI. Charges have been framed upon me under section 201 and 203 of the Indian Penal Code. Now, Lordship, if we may visit the Arms Act once. Excuse me. Section 14.3.
Yes.
It says, to be for any reason unfit for a license under this Act.
14.3.
14.3, Lordship.
Where the licensing authority refuses to grant a license.
Lordship.
What are you reading?
Section 14 starts with the heading refusal of license.
Yes.
And 14.3 says, where to be for any reason unfit for a license under this Act.
What is that?
Lordship, it's internal. Lordship would say
so it's 14.1.
14.1.3.
1.3. B3.
Now, Lordship, section 14 primarily deals with fresh applications wherein a license is prayed for. Now, the second provision under which my license has been suspended is 17.3b.
No.
If I may, Lordship.
Yes, ma'am. 17.
3b.
3b, yes.
It says, Lordship, if the licensing authority deems it necessary for the security of the public peace or for public safety to suspend or revoke the license. Now, Lordship, my license was issued in the year 1998. A criminal case against me is pending from the year 2007 in which the trial is going on. How have they suddenly come to a conclusion that me holding the arms license will be a threat to public peace and public security? There has to be a rationale and a logic based on the decision, which they are absent about. Upon receiving the first refusal, Lordship, I preferred a representation at Annexure 3, page 17.
Yes.
This was never replied to by the authorities. Post that at Annexure 4, Lordship, page 22.
Yes.
On the 20th of July, Lordship, I preferred a second representation. This was also not replied to, thus I filed an appeal. That would be at Annexure 5, page 30. To the appellate authority. Now, consequent to me filing of this appeal, my representation dated 28 July 2023 was finally disposed by the district magistrate by a second order of refusal that would be at Annexure 6, page 37.
That was in response to your appeal, or?
Lordship, when my second representation was also kept lying by them, I preferred an appeal,
Yes.
wherein I had stated that my representation is not being disposed of.
Yes.
Consequent to it, they disposed of my representation.
So that was in response to your appeal then?
Lordship.
37.
Page 37, Lordship, the type copy is at page 37A.
Yes.
If I may, Lordship.
Please.
With reference to the subject and your petition cited above, this is to inform you that as per the police report and the views from the Advocate General Meghalaya High Court, renewal of your arms license is subject to after the cases are dropped dismiss. Therefore, under Section 14.3 of the Arms Act 1959, read along with Section 17.3b of the Arms Act, it is required that you deposit the arms weapons at your respective police station. Lordship, there are two aspects in this order. Firstly, the order is saying that they have suspended my license based on some opinion, which is alien to the law. Now, no opinion can come up and say that me holding the license is a threat to public peace and security. My conduct has to be seen. There has to be an act which I have done or omitted, which is seen to be reasonable enough that there exists a threat to public peace or security by me holding that license. That is quiet, Lordship. Now, Lordship, there are three judgments that we are relying upon.
But are we finally hearing the matter? Have you?
They have the copy.
Notice?
I believe on the last date, Lordship was also of the opinion that it will be disposed of, but they were not holding the brief.
Yes, Mr. Sheikh.
Not here, affidavit is required, Lordship, because not only the renewal, that license has been suspended, Lordship. So let notice be issued. I'll file the affidavit and come up with the appropriate reply, Lordship. It's not question of renewal, Lordship, since the license has been suspended because of the pendency of the criminal case, Lordship.
Lordship,
So
this
appropriate
case was
affidavit
pending
is
from
required,
2007. My license was being renewed periodically.
Whatever may be. But he recently he applied for renewal. Not only question of renewal, Lordship, here. And the interim order clearly states that his renewal was not, the license was not renewed because of the pendency of the criminal case 302. So let notice be.
The interim order is very
What?
sketchy.
It's vague, Lordship.
Without the reply from the government, Lordship, very difficult for me to make any.
Lordship, because the scheme of the Act, right from Section 14 till Section 18, in spirit and letter, says that a license should ordinarily not, the application for a license also should not ordinarily be rejected. Leave aside the suspension of a license. And there has to be a proper application of mind by the authority concerned. Now, my weapons are kept with the police authorities, Lordship. I have deposited it. Annexure 7 is the deposit slip. Lordship, these weapons, they are made up of metal. They require proper maintenance. We have to allow them to breathe. They have to be oiled. They have to be taken.
There must be some procedure for the same.
They will keep it.
Lordship, the procedure is the owner himself, he does it. He's experienced to do it.
There's if such is a situation where they are kept in safe custody, with the
Lordship,
police or otherwise,
police will take care of
for which they are required to be, maintained as far as cleaning and oiling is concerned. There must be some procedure which will allow either the owner or an expert for that matter to do it.
Lordship, no better expert than the owner himself.
No. That could also be the case, but
Lordship,
if there are no specific rules, then you have to make an application.
Lordship, that being said,
because since Mr. Sheikh has, decided
without affidavit, how can
Lordship, the order on its face.
You see, this court would be,
And kindly
inclined.
come to
Prima facie,
Lordship,
this court would be inclined But again, you still have to give them portraiture. But as far as the maintenance of of keeping the said firearms intact, then I think you better find it actually.
If required, we
If
will.
required, then you can approach the competent authority for redressal. But Mr. Leonard Counsel for the Commissioner. Notice upon the respondent, only state notice upon state respondent has been accepted by Mr. S.C. Sheikh, GA. Such no formal notice is further required. The GA has submitted that he may be allowed to file a counter affidavit in this case to respond to the averments made in this petition. On premise, the same is allowed. Let the counter affidavit be filed within the next date fix. This is matter to petition.
Item number 2.
Lordship, as per order dated 22nd 11/2023, respondent 9 to 11 are yet to file their affidavit.
Yes, Dr. Musica?
But I have not been able to file.
Then what to do?
Only the matter is taken up, fixed in February. In the meantime, if I can file, where the matter can be handled.
Yet again, the learned DSJ has sought for accommodation in this matter as far as the filing of the counter affidavit on behalf of the respondents 9, 10 and 11 respectively is concerned. It is also the submission of the learned DSGI that if the counter affidavit could not be filed on the next date fix, necessary orders may be passed with this court. On pre-May, the same is allowed. This is matter in the third week of February.
Item number 3.
Please, Lordship. Lordship, as in the last occasion, we were directed to pay the ad valorem court fee, Lordship, and that aspect has been dealt with, Lordship, after proper consultation with the registry. Now, Lordship, we are applying for uncertified copy of the lower court records, Lordship. It seems the records are quite bulky and require some time, Lordship. So,
you have to prepare the
paperwork, Lordship.
Mr. Counsel for the petitioner, for the appellant, who has submitted that as per direction. Is there a direction in school?
In
Lordship, provide order dated 13/11/2023
as per
for the preparation of the paper books.
No, we are talking about the ad valorem court fee.
Ad valorem is by order dated 5/10/2023.
To go. As per direction of this court by order dated 5/10/2023, the appellant has inquired from the registry and it was confirmed. It has been confirmed that ad valorem court fee has to be paid, which, as on date, has been complied with. The Learned Counsel has also submitted that the paper book could not be prepared today and has sought for time for the same to be prepared. On pre-meet, seems allowed that the paperwork be prepared with copies to the respondents to be supplied in due course. Matter to be heard in the second week of February. Matter to be to come up with second week of February.
Item number 4.
We have filed our objections, my lord, to the condonation of delay.
So, Your Lordship, I want some time to file rejoinder, most probably after vacation.
My lord,
What is the delay?
my lord,
300 days.
there's a 300 days of delay, and the grounds stated is only one, saying that they are serious citizens unable to walk for a distance. My lord, but I have brought on records, and this is actually not at all a ground. This is not actually a ground to seek for condonation of delay also, my lord. It's not ground at all, my lord. If there are some other genuine grounds,
You look at the larger picture.
my lord.
More often than not, you see,
Yes, my lord.
the court would ignore,
My lord. But at least some reasonable thing has to come, my lord. It's simply saying that I'm old, it's not enough, my lord. And then I've brought on properly also, my lord, when did they apply the certified copy? When was the judgment passed? And they have slept all over, and then suddenly they wake up just before the filing case, they wake up and file a certified copy. There's so many things are there, my lord, which I have taken. Otherwise, I am also of the view liberal. It has to be construed, but there is nothing left here to construe liberally at all, my lord. Anyway, my lord, if my learned senior wants a date to, of course, rejoinder may not be required. We can
Sir, they are illiterate also, sir.
after vacation, my lord.
Have you given a copy?
Yes, we have given a copy, my lord.
Yes. Yes, Raman, Lawyer Counsel for the petitioner has submitted that copy of the response to the application for seeking seeking condonation of delay in filing the related review petition has been received by the petitioner, for which a rejoinder to the same may be allowed to be filed. On premium, the same is allowed that the said rejoinder be filed within the next date fix. Matter to be heard when the matter is this matter is to be heard after vacation.
My lord. Obliged.
Item number 5.
But here, on the last occasion, the condonation was allowed, my lord. So we require some more time to file objection, my lord, in the main case, in the review case.
Only a state respondent is involved.
State is there, my lord. She is for the managing committee. I am for the petitioner, my lord. The petitioner and the writ petition.
Yes, Ms. Ghosh, what do you say?
It may come after vacation.
You are for respondent? 8 and 9. And all the other respondents are there. They have received copies.
Yes, yes, sir.
Are there? Have they appeared?
Just check.
So, Mr.
Lord, I am for respondent number 7. My lord.
You are only for 7?
I am for 7. 8 and 9 is probably the school and the managing
Oh,
committee.
you are okay. You are for private respondent.
Yes, my lord.
And you are.
He's
so you are 1, 2, 3, 4, 5, 6.
Yes.
This 7, 8, 9. How many are there? Oh, so that's it.
Represented, my lord.
There are counsel for the heard Mr. H. Karmi, and an additional senior GA, as well as Mr. D.V. Bhattacharjee, Lawyer Counsel, appearing for the respondent 7, and Ms. P. Ghosh appearing for the respondent 8 and 9, who has made similar submission before this court seeking time to file the response to the review petition filed by the petitioner here. On primate, seems allowed. Let the said response be filed within the next date fix. This is matter in the 3rd week of February.
Much obliged.
Item number 6.
Please, Manoj. So far, condition concern, we have already concluded our arguments. In fact, my learned senior is supposed to reply on our arguments. Because on CRP 28, arguments be concluded.
Yes, I
for
think.
both
Your Lordship, we finished our arguments. We are left to file only our written arguments. Your Lordship, we require a bit more time.
Dr. Musika, you're supposed to
That is the court, my lord.
start the argument, or have this court heard you?
Not yet, my lord. I have not argued, my lord.
So,
The lordship would like to hear before vacation or after vacation.
you asking me?
It's quite a bulky matter.
You asking this court, or you're supposed to make a prayer?
My lord, I was, in fact, I was making a prayer, my lord. Go to next year, my lord.
On pre-made by the petitioner, this is matter of application.
Item number 11.
Yes, Mr. Deb.
So, Your Lordship, in this case, we have given the due diligence statement also, they already make payment. So, maybe they are not interested, so this.
Oh, they have come, they came, there's only that reconciliation of the statement, whether their calculation is correct or yours.
Even if this matters, if he is having any calculation, he may make them representations.
None appears for the petitioner. This is matter of the petition.
Item number 13.
May I please, Your Lordship? In this matter, I am praying for some time to file a written argument.
Have you filed yours?
No, Lordship, similar prayer.
And you don't need to file.
No, Lordship, we won't be filing.
On pre-made by the parties, this is matter of the petition.
Much better.